Hey everybody, this is Steve Gorin, and welcome to our webinar on spouses dividing retirement plan assets during life. So this is a joint venture of the American College of Trust and Estate Counsel, ACTEC, and the American Academy of Matrimonial Lawyers. We're also delighted to have with us members of the American College of Employee Benefits Counsel. This is our second partnering effort that we've done. We had another one at the time of the ACTEC annual meeting, and we hope to have more in the future. And certainly here you have a list of our panelists, and you're very welcome to email any of us with questions after the presentation. I'm going to go through now and describe some of the things that we are going to be discussing today. So this is spouses dividing retirement plan assets during life. And I'm going to go through right now the whole point of what we're doing. And so first of all, Ed Morrow is going to talk about how dividing retirement plan assets during life will give you asset protection benefits, help save state death tax, and also promote maybe income tax benefits. And Rob Clafine and Nancy Welber are going to talk about how the division can help get benefits. And you know, Ed's part's going to be relatively short, about 10 minutes or so. Rob and Nancy are going to go for about a half an hour. And so we really want you to understand why this is relevant for our various clients, and Rob has done several of these before to get these benefits, and then Marshall Willick from the American Academy of Matrimonial Lawyers does these things on a regular basis. He has a whole setup in his practice group, and we really are talking about qualified retirement plans and IRAs, and there's all sorts of other retirement plans that may need to get division orders. And so Marshall will talk about the gamut of those. And of course, when we think about it from a qualified plan, we think about a qualified domestic relations order, which most of us will call quadro. And I just want to get an idea of how many people are familiar with quadro. So this is just a fun polling question, and Donna's going to go ahead and do the polling question now. While she does the polling question, I want to know that I feel immensely gratified for the pronunciation that we've been using, because one of my partners pronounces it Qdro instead of quadro, and you know, but everybody in the call pronounced it quadro, so I feel redeemed with that. I also, while you're answering the polling question, wanted to talk a little bit more just about our partnership. So this is just an informal arrangement that ACTEC has with AAML and ACEBC, and we help each other with speakers. We have some cross-pollination opportunities available. If you do have questions in your area that in your practice that are relevant to the other colleges, we do have connections with it in ACTEC. Anybody's certainly welcome to contact me or also right now Steve Tritton to talk about connecting with ACEBC, and in the AAML, the person is usually the chair of the Family Law Task Force, and Ann Coventry chairs that right now. Wendy Goff is the vice chair. We're delighted that Ann was able to secure Marshall for us. So now we're going to go from some fun to getting into the discussion. I do encourage people to put questions in the chat. We have like 5 minutes reserved at the end, so we probably won't be able to get to most of the questions. But there's a chance that some of your questions will get answered in the chat. None of the speakers have committed to answering the questions in the chat, but in terms of making sure we get everything answered. But go ahead and try. We'll see what we can get to and see what kind of good discussion we can have. So thank you very much, everybody, for attending, and we're moving it on to Ed now.
Okay, thanks, Steve. I'll go ahead and share my screen here, and we may not get, we'll kind of go through a lightning speed a little bit on my particular slides. There's a lot for the only time that I have allotted here. Mostly my section is just to kind of scare you a little bit with some income tax and asset protection disasters and cases, and that basically are going to apply if you don't have somebody competent like Marshall and Rob basically dealing with the quadro and division of IRAs during a divorce or potential divorce successfully. What could go wrong? Basically, I just want to go through a few of those instances basically to kind of warn us about what happens if we get it wrong. So let's walk through a couple of these default rules for income tax planning and asset protection planning. The form matters to these particular divisions. If you have a retirement plan owner that just simply withdraws half of their IRA and they give it to their spouse, that's going to trigger income taxation to the IRA potentially, or to the IRA owner, potentially a 10% early withdrawal penalty if they're under 59.5, and potentially other penalties if there's a substantial understatement of income. If it's a Roth account, there may not be income tax ramifications, but there could still be a 10% penalty if they're under 59.5, and other penalties for Roth distributions. It might be a little bit different analysis, but generally, also, there could be ramifications to the donee spouse, because if it's an excess contribution and if it's not done properly, there could be a 6% excise tax as well. So let's just walk through a quick case, a couple cases to remind ourselves what could go wrong here. We had in the Summers case a young couple. They decided to negotiate the terms of their divorce and on their own and without any professional CPA or attorney assistance. And they decided they were going to divide the IRA. But before they got the order from the court, they did it themselves. The husband took half, gave it to a spouse, didn't go directly to her IRA. And they went to the tax court and said, well, this was pursuant to divorce. You shouldn't be taxing me on this, and I shouldn't be held to this additional 10% penalty. And the tax court said, no, sorry, form matters. You didn't do it properly. There was no order from the court. And so, hence, you had some nasty tax disasters. There's 2 other cases discussed here. The Bunny and the Kirkpatrick case are basically of the same ilk. So if you look at what 408D6 requires, you do have to have a divorce or separation agreement to basically get this non-taxable event when dividing an IRA. 408D is your IRA rules rather than the qualified plan division rules. If you do it correctly and it's pursuant to this divorce or separation agreement described in the next slide, then it's basically deemed to be owned by the spouse. And the new definition of divorce or separation agreement for this purposes is in clause I, divorce or separation of 121D3C, divorce or separation maintenance or separate maintenance or written instrument incident to such a decree. So remember that they're not incorporating clauses 2 and 3 here. They're not incorporating just any written separation agreement or any old decree. It has to be a decree or divorce or separation agreement incident to such a divorce or separation maintenance agreement. So let's just walk through an example of what doesn't qualify. There's a private letter ruling on this particular slide here that you've got on PLR 93-44027, where they had a private separation agreement, but they never filed any action with the domestic relations court. And so what happened in that particular case is the IRS said, well, no, that's not a qualifying divorce or separation agreement. You've got a separation agreement, but it's not qualifying under 408 of the code as a division of the IRA. So the nutshell case is there that just your private agreement without doing things properly in the form is not going to satisfy section 408 of the code. there's a little bit of a difference in income tax purposes between division of IRAs and other qualified ERISA type plans, and Marshall and Rob are going to go into that a little bit more in depth. But the key income tax difference is that you may be able to get, as a donee spouse of a quadro, you may be able to get at funds immediately without a 10% withdrawal penalty, unlike if I move assets to an IRA for my spouse pursuant to divorce. Once she takes money out without, and she's under 59 and a half, she's going to owe a 10% early withdrawal penalty unless she qualifies under some particular exceptions. And those exceptions that make the division under quadro a little bit different are in Section 72T, where there's a 10% early distribution penalty exception for a quadro that's not necessarily there for an IRA. Steve had mentioned that, maybe what are some potential tax benefits that there may accrue to being able to divide up an IRA during lifetime, even though the parties aren't necessarily divorced. Well, if we can make this happen, if we can divide up a large 401k between spouses, generally we don't have to, under federal tax law with portability, worry so much about equalizing estates. But there's still an advantage if I have a skewed estate where wife has $10 million in her 401k, or a lot of these doctors and professionals will have these really mega retirement plans sometimes. If you've got a skewed estate, maybe I'd want to divide things up for state estate tax purposes, because I want to be able to use the state estate tax exemption in states like Washington, Oregon, Illinois, that may have a much lower threshold for state estate tax. And, there may be some cases where I might want to divide up an equalized estate between spouses, even without getting a divorce. And so there may be some tax advantages there. The asset protection matters. And by asset protection, I'm not going to go into benefits, VA benefits, Medicaid benefits. Rob's going to cover that. But real quickly, walking through the asset protection debtor-creditor law regarding quadros, the general rule is kind of outlined in the Henry Nelson case. And that is that if you've got a qualified domestic relation order, or if you've got an IRA that's successfully transferred to the donee spouse, the general rule is that an interest as an alternate payee under a quadro is going to be protected under ERISA and under bankruptcy code, just as if the person had started out owning the property at the outset. So an alternate payee should be protected. There's a lot of cases that follow this Henry Nelson case, and there's another Walsh v. Dively case here discussed. So, with every general rule, we're worried about the exceptions, right? So a couple of the exceptions here, we have the Henry Kaiser case. And what we'll find from the exceptions is there's a couple general rules that we get from this, that sometimes it's the lawyering, sometimes it's the way that the bankruptcy, the plan wasn't done right, or there wasn't effective counsel. But let's walk through a couple of these cases just to give us the nutshell. Henry Kaiser, the debtor was denied an exemption as an alternate payee under University of Michigan plan and TIA-CREF retirement accounts. And, the court there said, no, this is kind of more like an inherited IRA. And they quoted the Clark v. Ramaker case, which is kind of strange because this is, not an inherited IRA at all, like the Clark v. Ramaker case. The nutshell, though, I think that this case was probably, wrongly decided. I think that in some respects, but if you get the quadro finished and then there's an alternate payee, you should still have protection under the case, under bankruptcy code. There's a couple of other cases where, like Henry Ehrman case, where you had no quadro divorce decree that delineated the ownership interest in the pension plan. And again, what the court said there was, well, there's no real, interest in the named beneficiary. There's no quadro that gives those rights in the plan under ERISA. And again, here's one of those exception cases where the debtors, the creditors got at the case here, or at the assets. The Lerbachen case, again, followed the reasoning in the Kaiser and Clark case. and found that the debtor's interest in their ex-spouse's IRA and half the 401k in the dissolution was not protected in bankruptcy. Again, he did not get a qualified domestic relations order or the qualified domestic relations order. And again, this is where dealing with good counsel, having somebody like Rob and Marshall do this correctly probably would have saved the day in this particular Lerbakken case. The creditor, coincidentally, in the Lerbakken case was actually the debtor's attorney. He didn't pay his attorney bill, and the attorney came after them. And ironically, because the process didn't get done, the quadro didn't get done properly, that's what caused the assets to be accessible to the creditors in that case. So kind of an interesting fact pattern in Lerbakken. So another thing is, if you get a case where the quadro does order an immediate distribution, and the quadro can order an immediate distribution rather than setting up account for the alternate payee, that might be a case where you've got an exceptional case where the debtor, alternate payee, those assets that are available to the debtor are going to be susceptible in bankruptcy court, like in the Woodyear v. Clark case here on this particular slide. So that's a quick summary of some of the asset protection issues. I think the Kaiser and Lerbakken cases are kind of wrong in part, or the debtors at least missed some crucial arguments. And you can see some discussion in footnote 4 of the Eighth Circuit decision in Lerbakken. They should argue that the 401k should be excluded under Section 541 of the Bankruptcy Code, not argued as exempt under Section 522. And so the lesson and solutions for any spouses that are receiving an interest in a divorce is don't delay in transferring it to their own IRA or 401k accounts. Make sure you get that order from the court as soon as possible. And under Reed and Ray Nelson, as long as the court's got the order, even though it's not qualified yet, there should still be protection. And of course, don't ask for an immediate distribution. Ask for the account to be kept at the qualified plan and keep it in a qualified plan, and the asset protections should still be there. So I think I've used up about my 10 minutes of fame here, Steve. I'll go ahead and stop sharing screen and leave those last two slides for later for digestion for folks.
Good morning. I'm going to take us through the Medicaid applications of quadros and transfer of IRAs to spouses during marriage. It's interesting. I mean, I've done this a couple of times in my practice. It's not something that comes up all of the time, but it does have an application in the right circumstances. So in order to understand how this works in a Medicaid context, you need to know a little bit about Medicaid. So Medicaid, and it's not to be confused with Medicare. Medicare it's the government's health insurance program for people 65 and older, and for people that are disabled. Medicare, we'll see a little bit, does cover some nursing home expenses, but it's very limited nursing home coverage. Medicaid, on the other hand, is this means-tested program that does cover nursing home expenses. And right now in our country, statistics vary, but anywhere from 45 to 65% of nursing home costs are covered by this Medicaid program. It's a voluntary program. The states don't have to implement a medical assistance plan, but each state, all 50 states, have opted into the program. And the basic deal that they're making with the federal government is they're going to follow some basic guidelines. And in exchange for following those guidelines, the federal government's going to pay a portion of the expenses. And it's a minimum. The federal government chips in at least 50% of the cost of the program, and the state picks up the rest of the share. It is interesting in this COVID situation, they've increased the federal match. It's the FMAP percentage has gone up for the states. And in exchange for that, the states had to keep people on Medicaid. So in the nursing home environment, some people that would have otherwise lost their benefits during the COVID pandemic, they've been able to maintain benefits because of that restriction. Since the states do have considerable latitude in how they administer these programs, we're going to see that it varies significantly from state to state. And even within the state, you can have variances from county to county, because most of these programs are administered on a county level. And that's clearly the case with respect to where we see variance with respect to IRAs and qualified plans. So Medicaid pays for custodial care in a nursing facility. I had indicated that Medicare pays limited nursing home expenses. Medicare only pays for skilled care in a nursing facility after a 3-day hospital stay. So what typically might happen is mom might fall and break her hip. She goes to the hospital and then she's discharged from the hospital to the nursing home. She's going to receive therapy at the nursing home, and that therapy qualifies as a skilled need under Medicare's guidelines. So Medicare is going to pay her bill as long as it's considered skilled. There's a maximum, though, of 100 days, and it's actually rare for people to receive 100 days worth of Medicare coverage. What's more typical is to see anywhere from 20 to 40 days worth of skilled care. And then when that skilled care ends, and this nursing home is required to give a written notice to the family when that skilled care ends, then that's where the family becomes responsible to pay privately for the nursing home. And nursing home costs, I have on the slide there, the average, national average is about $7,800, but it varies significantly across the country. You have, it's interesting, Oklahoma and Texas seem to be some of the least expensive states at around $5,000 per month. Alaska is an amazing $37,000 per month. I know on the East Coast, Pennsylvania, New York, Connecticut, Massachusetts, your average nursing home bill is around $12,000 per month. So this obviously impacts middle income, average people. So when they're faced with a nursing home expense, Medicaid is something they look for. They will pay privately until they qualify for Medicaid. And to get Medicaid, you need to meet certain medical and financial eligibility requirements. So Medicaid only pays for people that need a nursing facility level of care. It doesn't pay for assisted living, people who need personal care. Medicaid doesn't cover that. The buzzword, at least in Pennsylvania, is that you need to be nursing facility clinically eligible. If you meet that medical test, then we look at the financial eligibility requirements for Medicaid. And Medicaid makes a distinction between a person's income and their countable resources. So there might be income limits to get Medicaid, and then there's resource limits to get Medicaid. And as a general proposition, you're not going to qualify for Medicaid, the institutionalized person, if their income is sufficient to pay the nursing home bill, then they're not going to qualify for Medicaid. So income for Medicaid's purposes is something that's received periodically on a monthly basis. It's going to be Social Security. It's going to be pension. So if the person has $12,000 a month income, they're not going to qualify for Medicaid because that's going to cover the nursing home bill. On the resource side, and this varies from state to state, the institutionalized person, I'm going to say as a general proposition, can only have $2,000 worth of countable resources. And we're going to see, certain resources are exempt, but it's basically you can have $2,000 in the bank. And that does, like I say, vary from state to state. Some states have a higher limit. If the institutionalized person is married, then there's protections in place for the so-called community spouse. And that's really where some of this, transferring the qualified plan or IRA to the spouse, that's where these community spouse protections give us an opportunity to take advantage of that spousal transfer of the retirement account. One important aspect of these community spouse protections is that the community spouse does get to keep all of his or her income without any limit whatsoever. So what takes place is when the institutionalized spouse qualifies for Medicaid, as a general proposition, the institutionalized spouse's income has to go towards the cost of his care, kind of as a copay, and then Medicaid picks up the difference. But there is an allowance, and we'll see the details on that, where the community spouse is entitled to an allowance so that they have enough income as well. So if we're taking a look at the single person, I said that they can have $2,000 worth of countable resources. These are the exempt, or these are the major exempt resources. One is the big exemption is for the primary residence. So a single person in a nursing home can still own a house. It is subject to certain limits. So, and this varies from state to state. They have to count home equity if it exceeds a certain limit. So the lower limit there is $603,000. So in the state of Pennsylvania, if the institutionalized person has a house and it's worth more than $603,000, that excess home equity is considered an available resource. The primary residence, and this really isn't germane necessarily to the transferring of the retirement accounts, but it is important, I think, for me to mention, while the primary residence is exempt while the person's alive, as of 1994, states are required to have what's called a Medicaid estate recovery program. So while the house is exempt while the person's alive, upon their death, the state has a claim against their estate to recoup the Medicaid benefits paid out while the person was alive.
Rob,
In
let me
addition-
just point out one thing about the primary residence exemption. The 600,000 is the lower limit. There's also higher limits in other states that the
That's
state
right.
can
So
opt into.
the states can adopt, they have to have it's a minimum of 603. The maximum home equity limit at this point is $906,000. And those figures are adjusted on an annual basis.
Mhm.
I practice in South Central Pennsylvania. Most of the people in nursing homes, it's tough to find a house worth $1 million in York, Pennsylvania at this point. And those people don't tend to be in nursing homes, or they don't tend to be needing Medicaid. I mean, Medicaid is a program, for clients who come to me where they have net worths. I don't know where you draw the line, but in excess of $1 million, you get to 2 million, 3 million. Those people can afford to pay this nursing home bill without much of a problem. So Medicaid's generally not an issue for that group. This is for the 99.5% that Bernie Sanders is concerned about. Household goods and one automobile, household goods and personal effects, term life insurance, smaller life insurance policies. If the face value is less than $1,500, we're not going to look at the cash value. And then folks can have an irrevocable burial reserve. Those are the exempt resources. So where you have the community spouse gets to keep those exempt resources. So if the husband goes into the nursing home, the wife gets to keep the house, and then the wife gets to keep a portion of the other countable resources. And it's generally, and this varies from state to state, but it's generally 1/2 of the countable resources, subject to a minimum of 26,000 and change and a maximum of 130,000. And those numbers get adjusted annually as well. So if the husband goes into the nursing home, what they do is they take a snapshot of the assets that the couple owns on the day the husband goes into the nursing home. And is expected to be there for at least 30 days. So on that day, we value the assets, and let's assume that the couple has a house and they have $200,000 worth of savings. The wife is going to be able to keep the house since that's exempt, and 1/2 of the $200,000, she gets to keep a community spouse resource allowance of $100,000 in that example. If the husband goes into the nursing home and they have a house and $500,000 in the husband's IRA, then the wife is going to keep the house, and half of the $500,000 is going to be $250,000. So they only get to keep the maximum of $130,000. So if there's $500,000, the wife gets to keep $130,000, and there's $370,000 worth of excess resources. They're not eligible for Medicaid until they do something with that $370,000 in excess resources. And we're going to see how that plays out, if that excess resource might be a retirement account. And I had mentioned earlier, in addition to this resource protection that the community spouse gets. The community spouse is also entitled to a certain minimum level of income. So instead of all of the husband's income going to the nursing home as a copay, the community spouse might be entitled to keep a portion of that if her income is below certain limits. There's a minimum amount that she's entitled to have. They want her to have a minimum income of at least $2,178 a month, and a general maximum of about $3,250 a month. And that variance is based upon certain housing costs. So if you take into consideration mortgage payments, heat, real estate taxes, and the higher those expenses are, the more income that the community spouse is entitled to keep. But again, the community spouse gets to keep all of his or her income regardless of amount.
Now, let me just add that although there's a maximum, there are cases where you can actually go into court and get that maximum increased based on, the real life situation of that couple, and where, the spouse doesn't have enough to make mortgage payments or whatever it is. And it will really depend a lot on a bunch of factors whether you'll be successful. One of them is, the judge. Actually, I mean, it's very it can definitely be a crapshoot. You just don't know, and so you want someone who really knows the judges in the area and how to set it up. But it is possible to increase that community spouse resource allowance, and would be very important in getting the Quadro or IRA through to move some of that money to the community spouse. The other issue is, and Rob's going to talk about this in a minute, just how the states treat IRAs or qualified plans for Medicaid purposes, but also just generally the Medicaid agencies and how the courts generally or the states treat where the balance is between protecting Medicaid versus protecting the taxpayers and the beneficiaries of Medicaid. It just varies so much state by state. So if it's an area that you're not really familiar with, you're really going to need to know someone who really practices elder law and can get this through, knows how to get this through the court system.
Well, that's clearly the case. I mean, it's a very state-specific and, like I said earlier, county-specific. So it varies significantly. And that's one of the challenges of this area of the law. So it's not as if you can go to the statute, read the regs, and think that it's going to be applied that way. You're going to be surprised at times.
Mm-hmm.
We're going to see some of that some of the strategies people have used in the past to increase the community spouse resource allowance or increase the income allowance may not be necessary because of some other strategies that we use at this point. So another aspect of understanding how the Quadro and the IRA transfer to a spouse fits in has to do with the Medicaid 5-year look back. So when somebody applies for Medicaid, single person, they've spent down their assets to that $2,000 limit, they go in and apply for Medicaid, they are asked at that point in time, have you made gifts within the prior 5 years? And if they've made gifts within 5 years of asking for Medicaid, they're going to be ineligible as a result of making that gift. So what they do is they take the total cumulative gifts during that 5-year period, they divide it by the average monthly cost of nursing home care in Pennsylvania. That's around $10,000 a month. So if the Medicaid applicant has made gifts of $100,000 during that 5-year period, that $100,000 divided by 10,000, they'd be ineligible for Medicaid for a period of 10 months as a result of making those gifts. But the one key element here is transfers between spouses are not penalized. And that's because they pool the assets that are owned by the spouses in determining eligibility. So if we go back to my example where the husband went into the nursing home and the couple owned a house and they had $500,000 worth of resources, doesn't matter whether those resources are in the wife's name, the husband's name, or joint names, they're all pooled together. In that example, the wife was only entitled to protect that $130,000. And since we're looking at the joint assets, they don't care. We can transfer assets between spouses, and that gives us the opportunity to do these in marriage quadros. Other exemptions I've listed there are certain transfers of a house, transfers to disabled children. And if you can show the Medicaid agency that you gave money away for a purpose exclusively other than to qualify for Medicaid, there's no penalty. That's a difficult bar. So how do the states treat IRAs? And you can see this varies. It's all over the map. Most of the states will count the IRAs of both spouses. So those are the gray states on this slide. The red states exempt the IRA or qualified plan of both spouses. Now, in most of those states, you have to be taking RMDs, or the required minimum distributions, in order for the IRA to be exempt. So people that have reached their required beginning date, they'll be taking their RMDs, and in those red states, the IRA of both spouses is exempt, and you don't really have much of an issue. Although if it's a large IRA, the institutionalized spouse's RMD may be such that they wouldn't be eligible for Medicaid because of the size of the RMD. And then in the blue states, that's where the community spouse's IRA is exempt. And I happen to be in a blue state. So in Pennsylvania, if the community spouse has $1 million in the IRA, that's not counted in determining eligibility for Medicaid purposes. So what are we going to do here now that we've got that background? This is how protecting the IRA or the qualified plan for the community spouse kind of works. So as I indicated, in Pennsylvania, if I can transfer the institutionalized spouse's qualified account to the community spouse in a non-taxable way, I'm going to preserve 100% of the value of that IRA for the community spouse. In states, and this is the next part of this is really crucial, in states where the community spouse's IRA or qualified plan is countable, it still is extremely valuable if we can move the IRA in a non-taxable way from the institutionalized spouse to the community spouse, because once it's in the community spouse's name, there's strategy that can be implemented to protect that entire account. And this is because the Medicaid law looks at the community spouse's income separate from the community spouse's resources, and there's no limit on the amount of income that the community spouse can have. So any asset that's in the community spouse, if it's an IRA, qualified plan, that can be turned into income through the use of what's referred to as a Medicaid compliant annuity. This is a special form of a single premium immediate annuity that has to be irrevocable, non-assignable, has to be for a term certain, less than the actuarial life expectancy of the community spouse. And if you annuitize that IRA, that's considered income for the community spouse, and it converts that resource into a stream of income. And the states haven't liked this strategy, but it's been blessed by a number of courts, and most recently by the Third Circuit a few years ago. And so this is a strategy that's used quite a bit. So you don't know, elder law attorneys used to go to court to have the community spouse resource allowance increased or the income allowance increased. But by using this annuity, you can preserve the asset. The only catch is that the state does need to be, the annuity, most people will say, has to be a term certain annuity. So An 80-year-old female, for example, has a 10-year life expectancy under the Medicaid life expectancy table. She can annuitize an IRA over a 10-year period. If she dies, however, before that 10 years is up, the state needs to be the beneficiary of the annuity to the extent they've paid Medicaid benefits out for the institutionalized person. So getting the, so in Pennsylvania, for example, if I can get the IRA to the community spouse or the qualified plan to the community spouse, I'm taking something that would be countable and making it an exempt resource for the community spouse. But unfortunately, I believe in Pennsylvania that you can't do that with respect to an IRA without a decree of divorce. So as Ed was going through the material, with respect to a transfer of an IRA, it requires a decree of divorce or a decree of separate maintenance or an written instrument incident to such a decree. And I think somebody asked a question about what's a written instrument incident to such decree. It's my feeling that that would be probably some sort of property settlement agreement that was incorporated into the divorce decree or decree of separate maintenance. Not all states recognize this thing called separate maintenance either. So Pennsylvania doesn't recognize separate maintenance. If your state does recognize separate maintenance, then I think you can file an action for separate maintenance, which it's my understanding is that's an action that resolves the financial issues between the parties, but they still remain married. And so they still are a married couple for purposes of Medicaid. But because we can transfer assets between spouses without penalty, if you get a decree of separate maintenance, I think that you can transfer that IRA in full to the community spouse.
And Rob, I agree with that. In fact, that's what happens in Michigan quite frequently. And I want to mention one other thing about the annuity, which is you don't just go to any insurance company and ask for Medicaid annuities. There are companies out there that specialize in it. And again, people who do this work regularly will know who they are. So you've got to look around for it.
Somebody had a question in the chat about earlier when you were looking at the different colors of the states, and they were unsure which states were colored what. So.
Well, geez, I wish we would have. There's the slide. Yeah. So, and that slides. I mean, the slides in the materials.
Yep. Okay. Thanks. Go ahead.
Yeah. Nancy's point about the annuities, and it is. I mean, it's a really small market for companies that are issuing these Medicaid compliant annuities at this point. And a lot of that has to do, I mean, the market was a little bit larger a few years ago when interest rates were higher. With shrinking interest rates, these Medicaid compliant annuities make no sense in any other context. Mm-hmm. There's no return on the annuity. It wouldn't make sense to do this for any other reason than to get Medicaid. That was an issue that was raised in that Zahner case on a prior slide, where the state was arguing that this really shouldn't be treated as an annuity because there's no investment element, but the court rejected that. So another strategy that elder law attorneys have suggested with respect to moving the IRA to the community spouse, it is a strategy that takes advantage of Medicaid's rule known as the name on the check rule. So in determining whether this is income of the institutionalized spouse or the community spouse, the Medicaid rule is that it's going to be income of the person whose name is on the check. So some annuity folks have developed a strategy where the institutionalized spouse annuitizes his IRA. The institutionalized spouse is the owner and the annuitant, but he irrevocably names the community spouse as the payee of the annuity payments. And since those annuity payments, since the checks are written to the community spouse, the Medicaid agency should consider that to be income of the community spouse. And this apparently has worked in certain states. I don't suggest this to clients because I really have a serious question about whether when the when the institutionalized spouse names the community, irrevocably names the community spouse as the payee, that seems to me to be an assignment of the IRA that would trigger immediate income tax, and that's exactly what you're trying to prevent.
I agree. And it's something that, because the reason it quote works is because obviously they're filing a joint tax return. But it's not something that I've ever recommended or been comfortable with. But, I can't say that I don't know people who have done it. It's pretty common.
Wow.
Yeah.
So we talked a little bit about moving the IRA to the community spouse. Now we're looking at moving a qualified plan to the community spouse. And somewhat unfortunately, I think, is that, it doesn't really come up all that often in the Medicaid or elder law context, because most of the folks that are in the nursing home have long since retired and have rolled their qualified plans into IRAs. But certainly occasionally I have clients who still have a qualified plan, a 401k. And in those instances, we can use a quadro to transfer the qualified plan to the community spouse. So, and the big difference is that with respect to the quadro, it's not like the IRA where you need a divorce decree. With a quadro, it can be any court order made pursuant to a state domestic relations law. And so the way that I've done it, or the way that I've done it in the few instances where I've done this, is I have filed a support action. Actually, the first case that I did this in, it was a man in his 60s, had early onset dementia. His wife was even younger. She's in her 50s. He had a 401k of approximately $500,000. We filed a support action. The husband in that case, it was a second marriage. He was represented by his son, happened to be his agent under the power of attorney. He got separate representation. We filed a support action, and we settled the support action with a stipulation to transfer the 401k to the wife. And then that was presented to the plan administrator, approved as a quadro, and we were able to transfer the entire 401k to the community spouse. And like I say, in Pennsylvania, that community spouse's qualified plan is completely exempt.
Someone has raised in the chat, Kathleen Bay, about aid and attendance benefits for veterans, which is similar but not identical to Medicaid. And it is a useful question. If you have a couple, you should ask whether the nursing home to be spouse is a veteran, because they may qualify for these benefits. Again, there are people who really know these benefits and how they work, because they're not identical to Medicaid. So it would behoove you to find someone within your state that knows how they work, and have them consult with you on that type of a situation.
Yeah, aid and attendance through the VA is something you see more typically that assists with the payment of, say, assisted living expenses.
Mm-hmm.
When somebody goes into the nursing home, and generally speaking, if it's a single person, the aid and attendance stops. So it's not something we tend to use very much to pay for nursing home expenses, but it's clearly used quite often to pay for assisted living or assist with assisted living expenses.
Mm-hmm.
Rob and Nancy, it's time to wrap up so we get over to Marshall.
Okay. And so just on this final slide here, final point about there's case law there where, it's been litigated. There's a case out of New Jersey that approved the use of a quadro. And the bottom line is that because assets are pooled and making this eligibility determination, if you can transfer it tax-free, you're going to preserve the entire qualified plan for the community spouse.
Okay, so time for Marshall to go ahead and get started.
There is an old parable about a man who goes to a rabbi and asks the rabbi to teach him the thousands of years of Jewish law and custom while he stands on one foot. The rabbi thinks about it for a minute and says, what is hateful to you, do not do to your neighbor. All the rest is commentary. We're going to be simplifying a discussion of retirement benefits here, hopefully not to that extent, but be aware that each one of the subjects we're going to touch on can be and often is the subject of an all-day seminar. The point being that if you have any questions about anything we're going to be talking about today, please feel free to contact me or any of the other panelists, and we'll try to provide whatever information is desired about any of these subjects, because they're more technical than we can possibly get into today. The first question is, why should you bother dealing with these things at all? And the two answers for every professional dealing with either advising or litigating any of these matters is twofold. One is you have a duty to your clients, and the other is that you have a fear of liability if you don't. And they are both important. The assets that are in retirement plans are divisible upon divorce, and perhaps during any marriage pre-divorce, at least to the degree that they were accrued during the marriage. And there's a surprising lack of appreciation of the fact that they are most often the most valuable asset of a marriage, often worth more than everything else in a marriage put together, including the primary residence, which is not commonly known and seems to surprise people at all times. The materials that you've got include a discussion of some of the basic retirement benefit concepts and a laundry list of the history, sources, and acronyms for reference, including an introduction to ERISA, the Employee Retirement Income Security Act of 1974, the REA of 1984, and the difference between DROs and quadros. It also touches on the history of the major public employee retirement systems, matters of state versus federal law, federal preemption and general property law, and issues of professional duty and professional potential liability. All of that is useful background and is provided for your future reference if you end up in cases litigating it. The qualification requirements for private pensions, namely IRC section 414P and ERISA section 206D, are provided in the materials. They list the things that must be included in any such order and the things that may not be included in any such order in a quadro. Of course, you have to determine the kind of plan you're dealing with in order to deal with it intelligently. The question is, do the parties have a defined benefit plan, a defined contribution plan, or perhaps one or more of each? A defined benefit plan usually includes the kind of plans that used to be much more common when the terms of the plan define some kind of periodic benefit paid after a retirement date. There may be employer contributions, employee contributions, or both. The plan typically provides specified benefits to the employee after retirement and usually for life. Often the benefit is determined by a formula, taking into account the highest salary received and the total number of years worked for the employer, such as a high 3 or a high 5 plan. Some mathematical examples are set out in the materials. It is worth noting that the primary retirement benefits provided by the civil service under CSRS and FERS for military retired pay and for most state retirement plans are all variations of defined benefit plans. The standard time rule formula seems simple enough. The spousal share is determined by taking the number of months of service during the marriage as a numerator, the total number of months of service as a denominator, and multiplying the resulting fraction by first 1/2, which gives you the spousal share, and then by the retirement benefits received to determine how much is payable. Yet there are variations around the country in terms of what is counted, leading to very different ultimate results. Courts in different states often don't even realize that the time rule cases decided elsewhere follow different sets of rules and assumptions. Again, I'd suggest reading the materials on this because it can be a little bit more subtle than it appears, but we don't have time to get into those distinctions here. For defined contribution plans, things are typically simpler. Such a plan is one in which there's some specified account balance out there in the universe somewhere, and it's contributed by the employer or the employee, and there's an individual account balance somewhere, so that every employee has a balance in a plan at any given time. A defined contribution plan generally pays lump sums, but they could offer other forms of payouts. The most common examples of defined contribution plans are discretionary profit sharing plans and formula plans, like money purchase, target benefit pension plans. Other examples would include employee stock ownership plans, ESOPs, simplified employee pension plans, those are the SEPs that are shown up in the chat box, and simple 401k plans as well. So what do you do if you've got a case and you are concerned that the asset might disappear? And the usual advice for divorce lawyers is freeze it. As a practical matter, every litigator dealing with retirement benefits should ensure that the asset doesn't disappear, because the failure to do so could be a devastating loss to the client and could even lead to lawyer liability. And usually doing so is pretty simple. Most plans, if you send them a certified letter that you're in litigation, they will simply clamp the plan down. And that should get you a couple months of coverage. A better idea is to send a restraining order of some kind. Most states have something like a joint preliminary injunction or similar other form, and that usually is sufficient to keep the plan from disappearing. But be aware that it's usually possible to get a hardship withdrawal from a plan based on the fact that a divorce is ongoing. So there can be some gamesmanship in the litigation. Also, and this also answers one of the questions from the chat box, it's usually possible to get a temporary quadro in place during the pendency of an action, which can be very valuable if you think a party might die or otherwise things might change during the pendency of a case, or if the benefits are already in pay status, to make sure both parties are funded during the progress of the case. So what do you do? And the answer is, if you're doing anything between parties and there is a pension plan of any kind involved, you should be considering the existence of that plan as part of your planning and execution of whatever document you're doing. A DRO, or domestic relations order, is any judgment, decree, or order, including approval of a property settlement, which relates to the provision of child support, alimony, or marital property rights to a spouse, former spouse, child, or other dependent of a plan participant. A domestic relations order, a DRO, must be made pursuant to some state domestic relations law, including community property laws, under which state authority, some court, actually formally approves a property settlement agreement. And to answer one of the questions in the chat box, you don't need to have a divorce case. You can have a separate maintenance action. You can have a legal separation case. You can even have some sort of miscellaneous action in a lot of states. Again, if you're into the weeds and you're trying to figure out what you can do in order to get an enforceable order to avoid the Django case that was talked about in the prior slide deck, just call one of us that do these things regularly and we will try to assist you. But realize that just an agreement is not a DRO until it's been adopted by a court. And note, there might be more than one or two or three plans to address, and possibly there could be some in the names of each spouse. So it sometimes is more difficult than you might think to track down and get to everything. One of the questions for this seminar was asked, are you concerned about the possibility of a sham or collusive divorce? There's an old saying that a lawyer is not ever entirely comfortable with a friendly divorce any more than a mortician wants to finish the job and have the patient sit up at the table. But most authority says that a plan may not look behind a quadro to find out what's really going on. And we've included in the materials the blue and brown cases, which talk about the idea that there is really no such thing under most courts' interpretation of a sham divorce. It is important for anybody doing a quadro or similar order to ask a handful of pretty straightforward questions. You have to ask what's going to be available in the form, whether it's going to be a monthly annuity or with a lump sum option, whether there might be more than one plan associated with a particular wage earner. You have to ask about the amount of the benefit that's divisible community property or other marital property under the time rule, under direct tracing, or under some other analysis. You have to talk about when the sum is going to be first available for distribution. It isn't always available at the date that your order goes into place. Depending on the kind of plan you're dealing with and the qualifications that are required, there could be age-related or other stops to being able to distribute benefits. You have to find out what steps have to be taken by either party to accelerate or delay the availability of those benefits. And then finally, you have to ask if there are survivor benefits that might be accorded to a former spouse in addition to or in place of the retirement benefits, who's going to pay for them, and then ancillary benefits. We don't have time to get into it, but typically health, welfare, insurance, sometimes bizarre other things in the military world, for example, commissary and theater privileges. But there's often ancillary benefits that are attendant to retirement plans that should be looked into. And after you get to those basics, you have to look into some other matters that should be consciously addressed in every case involving pension benefits before the case is over. You have to find out what notices are required to be given, within what time limits, to which authorities in order to make sums payable to the spouse or to permit the transfer of the other interest. You have to ask what effect a present or future disability could have to undo or increase the amount of benefits available to the retiree or the former spouse. Sometimes, especially in the military context, a disability award can completely undo a division of benefits and dispossess the spouse entirely. There's some of that in the materials, but if you run into a situation like that, I suggest you contact us and I'll go into much greater detail for your individual circumstance. You have to ask whether and what post-divorce actions of either of the parties, such as remarriage or a nomination of a second spouse as a beneficiary, could affect the distribution of benefits provided by the decree. Sometimes, again, it can be undone or modified, and sometimes not. If you don't deal with all of those factors in litigation or negotiations, especially in court orders, there can often be unforeseen and unfortunate results for parties or for counsel or for both. Practitioners should distinguish in every case the benefits expected to be provided by a plan from the value of that plan, which is a different matter entirely, and distinguish both of those concepts from contributions. You'll see a lot of people, especially in an adversarial position, attempting to confuse those three concepts, and they can be very, very different things. The benefits are what the retiree will actually receive upon retirement. Usually that's phrased as a right to receive benefits. The value is generally considered to be equal to the cost at a given time of acquiring, say, an annuity that would pay the level of benefits to be expected. And the contributions, whether from the employee or the employer, may have no correspondence of any kind to either the benefits or its value at any given time. So always remember that the pension interests are property and not alimony. You'll see people attempting to undo pension awards based on remarriage, which is usually not something which happens. However, in certain state plans, the existence of the marriage can't alter the eligibility of the spouse to have survivorship benefits. The materials include a non-exhaustive list of the things that any drafter has to do to craft a proper order in every case involving a private pension quadro under ERISA, but we don't have time to get into that here. There are samples in the materials and certainly are available for private and public plans of various kinds, but I will again caution you, do not use models without knowing exactly why what is set out in the model that you're using. You can seek in most plans preliminary approval, pre-approval of the plan. You take the order, you don't need to have anybody sign it, you submit it to the plan administrator, and they will tell you whether or not it will be good. And it works for private pension plans under ERISA, usually without cost. But most private and state government plans have some sort of pre-approval process, but not federal public plans like military and civil service. If you have those, you will not be able to submit it for pre-approval. So you have to try to get it right the first time. And getting back to the point I mentioned a minute ago, do not copy forms. The plan model quadro ensures that the plan is protected. They are not there to protect the client, and they sure as heck are not there to protect you. Stuff that is perfectly legal and appropriate might be left completely out of a model pension plan, they can vastly underestimate certain benefits. They can under or overcompensate one side or the other. And if just copying a form can lead to a lawyer getting sued. For example, there's an awful lot of model pension plan forms that don't even deal with survivorship benefits. And about half of my expert witness work concerns liability claims against lawyers for missing or messed up survivorship provisions. The lesson there is just because it qualifies doesn't mean that it's right. And if you're in doubt, get assistance from somebody else. Most people that practice in this field are very happy to answer questions. We get them literally every day by email and phone, and we'll gladly answer the questions that you've got. My contact information is in the materials. I know we're going at light speed here, and we're going to deal for the moment with stuff in the other world, the federal plans, which has its own screen share. There are special considerations that you have to get to when you are dealing with a government plan. And we're going to start with civil service benefits. In short, there is a defined benefit plan, a defined contribution plan, and there are health benefits. And you really should deal with all three when you are dealing with anything relating to the civil service. The civil service retirement system is the old system before 1984. The federal employees retirement system is the new system after 1984. Under both, the federal statutes permit paying the former spouse either all or a portion of a retiree's benefits. So in that way, it's a little bit like ERISA. It's essentially a defined benefit plan, the core plan. And since 1984, there's also a defined contribution plan known as the Thrift Savings Plan, or TSP, which is administered separately by a separate agency. And it's got its own guides. There is guidance available for civil service systems. There's online something called a handbook for attorneys, but it was written by the same people, I think, that wrote the tax code, so it's extremely difficult to read. In dealing with the OPM, which is the administrating agency for civil service defined benefit plan divisions, you have to be aware of a whole bunch of stuff. First of all, never use the word quadro when you talk to those people. They're allergic to it. In OPMEs, the word is COAP, court order acceptable for processing. Never use the term alternate payee because the OPM term is former spouse. They use very weird language, and they have redefined words that you thought you knew. For instance, the word accrue does not refer to accumulation in the OPM world. It means commencement of payments. The employee annuity means recurring payments, not the account itself. In other words, it's a verb, not a noun. Even the word gross doesn't mean all. In the OPM world, self-only means all. Gross means self-only minus survivorship premiums. The retirement account only refers to contributions, not to the whole annuity. So my point is, and this isn't a comprehensive list, using the words you think you know in the world of OPM could actually cause an incorrect order and can get you sued. So there's a lot of technical rules, and some of the most critical ones are recited in the materials. But again, the trick to trying to minimize your exposure to liability is to find somebody who deals with these worlds regularly and utilize them in assisting you in creating orders that will pass muster and not cause unintended consequences. Every COAP in the civil service world should include a minimum of three things: the lifetime benefits, called the employee annuity, the potential refund of employee contributions, and death benefits, which are the former spouse survivor annuity in OPM language. Just like in ERISA-based private plans, but unlike in the military and most state plans, a spouse can be awarded up to 100% of the retirement benefits. That isn't possible in some of those other plans. There's a lot of little technicalities that are basically landmines or traps for the unwary. For example, the phrase creditable service tells OPM to calculate the spousal share to include accrued unused sick leave in addition to the actual time in service. But if you use the phrase total service, which you might have thought meant the same thing, or service performed, which you also might have meant means the same thing, it tells the OPM to not include unused sick leave in the calculation. leading to often very different and valuations and distributions of money. The regulations allow a percentage, a fraction, a formula, a fixed dollar sum certain, or a pro rata share of either the self-only, the gross, or the net payments. So there's a lot of options, and you have to be extremely careful in the language that you use, because just a slip of the tongue can cause the what you're doing to have a very different effect. Survivor benefits are very different in the civil service world than they are in any other retirement plan. The spousal share reverts automatically to the retiree upon the death of the spouse, unless the court order provides that those benefits are paid into court, paid to an officer of the court acting as a fiduciary, paid to the estate of the former spouse, or payable to one or more of the retiree's children. This is the only retirement plan known which has these options available, and it is selectable in the form of the court order. The biggest malpractice trap of all in civil service world is weird rules requiring that all divorcing, remarrying, and adjustments to orders relating to civil service have to be done while the employee is still in service, or that the first order entered after retirement of the worker deals with every single aspect of the retirement and survivorship benefits perfectly. Amendments may not be issued after the date of retirement or death of the employee that modify or replace the first order dividing marital property. And I know that's a little weird and is not true in all systems, but it is a huge malpractice trap in civil service cases. Any order that awards, increases, reduces, or eliminates a former spouse annuity, a survivor annuity, or explains, interprets, or clarifies any such order has to be issued prior to retirement or death of the employee, or the very first order dividing marital property. In other words, if the employee is retired, your very first court order must be the final order for the civil service benefits. Because if you just put in a divorce decree or some other document involved with people, a co-op is to be entered later, it's too late, and you may very well get sued. The thrift savings plan, this is the defined contribution plan. It's basically the government 401k. It's a mechanism for diverting pre-tax funds into retirement savings, and since 2012, there's been a Roth pre-tax contribution option for these things. It is not administered by OPM. It has its own board, and orders for division must be sent to that other board. Withdrawal and borrowing of money from the TSP during service is possible and should always be thought about by a lawyer if you have any litigation between the parties. Note that a special category for financial hardship withdrawals is a legal expense for separation or divorce. So it's anticipated that money can be pulled out for that purpose or during a domestic relations case. Spousal consent is supposed to be required for withdrawal or loans against the TSP, but don't count on it. We have run into situations where apparently that's been evaded. The TSP board should honor a joint preliminary injunction, but again, don't count on it. Always try to verify. There is withdrawal and borrowing of money from the TSP after retirement, but there's other rules to follow in order to take loans or withdrawals. We can't get into the technicalities here, but they are at least briefly recited in the materials. Dividing a TSP is actually a lot easier than doing a full co-op, but there are a few tricks. A TSP order has yet another acronym called a RIBCO for Retirement Benefit Court Order. You don't need a quadro for a TSP distribution. How you do the withdrawal or rollover determines who's stuck with the taxes. So there are planning opportunities throughout the TSP defined on how you choose to allocate in which order things are done will alter who is paying the freight for the taxes on the withdrawal of sums. And you have to be very careful as to whether and how you provide for interest and earnings. You can even specify your own interest rate for a TSP withdrawal, which a lot of people don't know. There are no survivorship benefits per se for a TSP because it's a cash plan like a 401k. So the beneficiary designations basically control who ends up with stuff in case the named participant dies. There are medical benefits, which are not truly at issue here, but what I wanted to be important for this group to know is that if there's a divorce in question, there are very strict timing requirements. The post-divorce spousal health benefits for the civil service require an application within 60 days. And if you blow the time limit, you will lose the medical benefits, which could be extremely valuable. And it leaves the spouse uncovered and can also lead to to attorney liability. This is FEHB, the Federal Employees Health Benefits. To be eligible, the spouse has to receive either a portion of the annuity under the co-op or a survivorship benefit. There are restrictions and remarriage rules to warn the client about. Again, we don't have time to get into it, but there's a lot of technical details that should be known. If you end up with somebody in this situation, just know exactly what you're doing. We're going to pivot to military. A military retirement benefit seminar can easily be a 1 or 2 day seminar. So please forgive me if all of this is horribly oversimplified. Military cases implicate retirement, both defined benefit and defined contribution, plus disability, survivorship, and medical benefits. All of that stuff is at issue in every single military case. First, on the retirement side, the USFSPA, the Uniformed Services Former Spouses Protection Act, 10 U.S.C. 1408, is both jurisdictional and procedural. It permits the state courts to distribute military retirement to former spouses and provides a method for enforcement of those orders through the Military Pay Center, often called DFAS, for the Defense Finance Accounting Service. The USFSPA itself does not give former spouses, however, an automatic entitlement to any benefits. So we have seen cases where courts have said that if a court order simply says, well, the spouse has received all the benefits to which she is entitled, she gets nothing because she doesn't have a specific entitlement. It's an enabling statute. And whether the spouse gets anything is defined by state law, not by federal law. There are at least 3 different possible ways of calculating military retirement benefits, depending on the date the member first entered service. We don't have time to get into it, but the age of the people and when they went in and got out alters what is payable and how it's payable. If somebody was a reservist, there are still other requirements and rules. And the biggest one is that a reservist must accumulate 20 years of creditable service and generally be age 60, although that can be shortened in some cases. And in the military world, it's possible, by the way, to mix and match reservist and active duty time, but how to do it is too complicated to explain here. If you have mixed service cases, I strongly suggest you bring a professional in to assist you in figuring out how to express what to do in the order. One important thing to distinguish military from, say, civil service or ERISA cases is there is no way for a spousal share of a military retirement to be left to a survivor. It automatically, and in every case, reverts to the military member in the event of the death of the spouse prior to the death of the military retiree. Military retirement benefits can be treated as property to be divided, or they can be treated as a source of payment of child or spousal support or other property, or both. There are special jurisdictional rules to divide military retirement as property. It's limited to 50% of the disposable retired pay, and possibly more if arrears and support are also being garnished. And I mean, the bottom line is that the military system is the most restrictive and limited of all federal and private retirement systems in terms of spousal rights. And it is the easiest system in which a spouse can be totally divested. However, in the military cases particularly, almost always the military retirement benefits are the single largest asset in any military marriage. There's a lot of peculiarities for military cases. The so-called 10-year rule, never get suckered into that. By the way, understand that the restriction for the 10-year rule is upon direct payment only. It is not a limitation on substantive rights. And what that means is whether the marriage overlapped military service by at least 10 years. There are workarounds, and those are listed in the material. There's a lot of new stuff that's happened in the last few years in military cases. There's now what they call the blended retirement system. It's more complicated than we can get into. It is described in the materials, and we can have other materials that we can give to you. There's a better explanation on the Military Retirement Benefit Divisions page of our firm website if you would like a more detailed explanation. But basically, the blended retirement system reduced the value of the defined benefit portion of military retirement significantly, from 50% to a 40% multiplier. The TSP has been made much more valuable. There's now a government match to the TSP that didn't used to be there. There are now mid-career status bonuses which may or may not be divisible. And there's now a lump sum option for military payouts, which can be either 25% or 50% at the moment of retirement. And getting the spouse secured there can be extremely difficult as well. There was a huge change by the Defense Authorization Act of 2017. It gave us something called the frozen benefit rule. It's financially complex, but the short version is that it greatly reduces the spousal interest whenever the divorce of a military member occurs during the active duty of the military spouse. There are workarounds in our materials and posted on our website, but it's extremely intricate. Even most quadro drafters do not know how to do this stuff very well. So if you end up with a current military member, you are in a divorce situation and you are trying to secure a spousal share, I strongly urge you to find an expert. There are a few around the country who know about these things. And if you need referrals to people, again, contact my office and we will attempt to assist you. Disability has become a major problem after the Howell case a few years ago. The United States Supreme Court basically killed the concept of indemnification for disability, which had been present and recognized in virtually every state in the union. Short version is that if there is less than a 50% disability, the spouse can be retroactively shortchanged from, even if the court order says that she's supposed to get a portion of the benefits. A well-crafted alimony backup, not running afoul of the case law, seems like the best option in most places. It won't work in Texas, but it does work in most places. And I strongly urge you, if you have a military case and you're trying to come up with the proper phrasing of an order, get expert assistance, because this stuff is not well known and there's very few people that know what to do or how to do it. A VA disability cannot be divided as property, but it can be a source for alimony or child support. So pay attention to what is tax-free money versus taxable money. There is a great deal of difference between it, and it could be some of each in a military case. There is lots of complexity to any case involving military disability, whether that disability is claimed before or after the retirement and before or after the divorce. And military retirement can also be rolled into a civil service retirement, which has its own series of rules. But let's turn briefly to the survivor benefit plan, which is the spousal benefit for a former spouse in a military case if the military member dies first. If the spouse dies first, the spousal share automatically reverts to the member. But if the member dies first, it depends what your order says as to what will happen. If there's no SBP, the spousal payments simply end. And there have been a lot of malpractice cases where that's occurred. State courts can order that former spouses be member survivor beneficiaries, but there's precise and technical rules to follow to actually make it happen. For example, and counterintuitively, the SBP is suspended if the beneficiary remarries before age 55. It's not terminated, it's not lost, it's just suspended. So if you have one of those cases, read the materials closely regarding elections and deemed elections. We've posted most of the forms on our website. The amount of the survivorship interest is variable in a military case, but doing so is somewhat complicated. The smaller the base amount selected, the smaller the survivor annuity, and the smaller the premiums paid. Who pays what can be adjusted indirectly, but not directly. So on the face, but not on the face of the court order. There's an explanation, again, in the materials, and the rules are very strict. The benefits are very easy to lose. And malpractice cases in this area can lay dormant for many years until people tend to die in an inconvenient order. There is a calculator on our military retirement benefits page for how to adjust the benefits in order to vary the amount of the SBP. And there's an explanation on the site for how to use that. But be very careful that if you do have an SBP, you get the order in within a year of the decree. Huge numbers of malpractice cases have occurred where people don't get around to sending stuff into DFAS in the amount of time in question. There are also other benefits. There's medical benefits, which require various other rules. There's something called the 20-20-20 rule, 20 years of service, 20 years of marriage, and 20 years of overlap. There are some lesser benefits for lesser overlaps. There's a lot of restrictions. Like Social Security, this is an entitlement program. So the key for lawyers is never bargain for it because it costs the member nothing. It's also possible for a premium with prompt application to get temporary health benefits under something called the CHCBP. And we don't have time to get into it, but the explanation is in the materials. If health benefits are important, and they often are, you should look into all of the possibilities for actually getting them. The limits and the criteria are in the materials, and I suggest you look at them. Also in the military, there is now a TSP. And for all current military members, it's essentially automatic. For older military cases, it was optional, so it may or may not be there. And again, it can be regular, or it could be Roth, so it might be pre-tax, might be post-tax, could be some of each. There are special jurisdictional rules for all military cases, and it's a little weird. In most other public and private plans, any valid state court judgment, which is valid under the laws of the state where it was entered, is considered enforceable in terms of the retirement benefits, but that is not so for military retirement benefits if you're dividing them as property. An order dividing military pay as property of the member and the former spouse is only going to be honored by the military if the issuing court exercised personal jurisdiction over the member by reason of residence in the territorial jurisdiction of the court other than by reason of military assignment, or domicile in the territorial jurisdiction of the court, or consent to the jurisdiction of the court. This is sometimes given the word federal jurisdiction, for lack of a better label. Realize that it overrides state long-arm rules and other state law, and it must be satisfied in addition to all state law jurisdictional requirements in order to get a valid military member. If you want to have a rule here, it's never take a default against an out-of-state military member. And the easy way of remembering that is if you take default, default is yours. So just don't do it. Bad things will happen. Pivoting to a few other more niche plans, there are railroad retirement benefits. Railroad retirement benefits, the most important things to know is that there's two tiers. Tier one is like Social Security. It can't be affected by a court order. Both the employee and the spousal share are entitlement systems, just like Social Security. And the spousal share, if payable, does not reduce the employee share, just like Social Security. Tier two should be dealt with just like any other pension. It's divisible. And you should note that, like some state plans, but unlike military retirement, early disability awards are fully divisible in the railroad retirement system. In every railroad retirement case, the key takeaway here is always look for private benefits in addition to the railroad retirement benefits. Frequently, there are defined benefit plans, defined contribution plans, stock option plans, and other plans in the name of those employees, which were provided by the individual railroads that they work for. And those should be divided by quadro in addition to the railroad retirement benefit division order. I realized that was a lot more information than anybody could possibly hope to absorb in the amount of time we went over it. This is my contact information. Please feel free to write to us at any time if you have any question about any of this stuff, and we can at least refer you to other information which might be useful to you in trying to deal with one of these plans.
So thank you so much, Marshall, for a great informative group of information here, and I thank all of our panelists. I appreciate all the attendees for attending. And I appreciate also the partnership of the Elder Law Committee and Asset Protection and definitely, again, the American Academy of Matrimonial Lawyers and American College of Employee Benefits Counsel. If you have any suggestions for other topics to consider, feel free to email me directly. And the recording will be available. So there will be dissemination to ACTEC fellows through the weekly report, and there will also be several dissemination to the AAML and ACBC fellows. Thanks very much. Look forward to getting together with you next time.